Hello, TikTok. Hello, Facebook, YouTube. Today we're live at the same time. I hope everyone is doing great. We have a super exciting topic to discuss, live US immigration updates, as well as something that you need to understand. So please join in. We have a really lively US immigration discussion today. You got to be here. You got to stay tuned until we're done. If you can hear me and see me good, drop USA in the chat box or in the comment section. Please let me make sure that across platforms you guys can hear me and see me well. Type USA or drop the US flag. And let me make sure you guys can see me and hear me good. As always, I'll be sharing my screen on YouTube, Facebook, LinkedIn. So if you want to see the document I'm using, today we'll be using the USCIS Policy Manual as the source of our discussion. 2 chapters in the Policy Manual. We're going to be discussing this really interesting topic. It's coming up a lot, and so you have to know what's going on. Even if you qualify for an immigrant, oh my gosh, okay, I think I see what the problem is for Instagram. Thank you for telling me. Oh my goodness, the mic was somewhere. Thank you. You see, this is wonderful that somebody alerted me our Instagram audio was not good. So, okay, there you go. The mic was hiding somewhere. Can you guys see me and hear me well on Instagram? Is it clear now? Please confirm, drop USA if you can hear me across the platforms. Let's make sure I'm not talking in a vacuum. I remember some time ago, somebody started their live video and talked for like what, maybe 30 minutes, or it was recording for about 30 minutes, an hour, only to realize everything was muted. So we don't want that to happen. I don't want to talk to myself. Please drop USA if you can hear me and see me well. Instagram, LinkedIn, YouTube, Facebook, TikTok. Please drop USA, put the US flag so that I can be sure you can all hear me and see me great. Okay, now let's get started. We're going to be talking about something really important. And you guys, you have to know that even if you apply for an immigration benefit, a US immigration benefit, like a green card, or you apply to have your status extended or changed from non-immigrant, you're extending your status as a non-immigrant, or you're changing your status from one non-immigrant status to another. There's something called discretion. A lot of the immigration applications, there's a discretionary element that the officer that will be reviewing your case will determine in order to grant you or deny your application. So for the officer to say yes to your case or no to your case, not only are they looking at eligibility, which is the foundational thing they have to look at. Are you eligible? Do you meet all the grounds of eligibility under the benefits you're seeking? And then after they've done the eligibility analysis, they go on to something called the discretionary analysis. That's what many people don't know about. If you're a lay person, for example, it's for many people, they'll just they'll put their names on forms, fill out forms, add pictures, and send it. They don't know or care about standard of proof, burden of proof, or even something called the discretionary analysis. And my Christian brothers and sisters are going to be very happy today, because as I was reviewing the material, and it's something that has always struck me. There's something called administrative grace, even in law, administrative grace. And that's administrative grace or adjudicative grace, even in courtrooms, after you've met. And sometimes even in courtrooms, you may not have met everything well, but the judge will exercise some discretion and might let you go scot-free so that you are not imprisoned or whatever, So these are, when it comes to US immigration, there's an element of grace, an administrative grace, which is a legal term. And I'll be telling you all about what things the officers are looking out for to approve or to deny your case. Okay. Now let me start with this. Let's go here. Let me start with this. Okay. So in many immigration applications, you, the person who is seeking the benefit request, you, the one who's asking, oh, USCIS, can you give me a green card? Or USCIS, can you give me a work permit so I can work for any employer in the United States? You have to prove that you are eligible, you qualify for what you are asking. If you don't qualify for what you are asking, it cannot be approved. And number two, you want to tell USCIS or show to USCIS that they should exercise discretion favorably in your case. It means that they should look at your positives or that you warrant a favorable exercise of discretion. So it's not just about qualifying. You have to show that you warrant a favorable exercise of discretion. So where there's, some of the immigration benefits statute has said specifically that you have to meet the statutory and regulatory requirements. However, even after meeting that, there must be an analysis of discretion. Does it show, or does the totality of the circumstances show that this person is entitled to the benefit he's seeking as a matter of discretion? I'll tell you guys what discretion is very soon. So hold on. Now, in some immigration applications, there are no discretionary analysis. Some of the immigration benefits are not discretionary. In those cases, if you file as an immigrant or as a requester, and you properly file and you meet the eligibility requirements, USCIS, they must approve the benefit request just by reason of the fact that you've met statutory and regulatory requirements. There is no discretionary analysis as part of the adjudication, and these requests cannot be denied as a matter of discretion. I'm going to give you guys examples, specific examples of case types where USCIS will utilize discretion, or the law requires that USCIS will use discretion to grant or approve, and will mention some immigration benefits where USCIS is not required to use discretion or should not use discretion in those cases. Okay. Now, there are two broad types of discretion that may be exercised. Two broad types of discretion that may be exercised in the context of immigration law. The first one is called prosecutorial or enforcement discretion. Should an agency enforce something against you or not? Then the second type is called adjudicative discretion. In this video, we'll be talking about adjudicative discretion as it relates to USCIS and when you apply for green cards, citizenship, change of status, asylum, all these extension of status, change, all these things. We'll talk about them. Now, what is discretion? The multi-million dollar question. Discretion just means that USCIS officers have the power to say yes or no to an immigration benefit, even if you meet all the basic requirements. We've already said that the law allows them to, or the law mandates that they use discretion in some case types, and in other case types, they are not allowed to use discretion. I must mention that discretion is not just arbitrary, or they're just, I like this guy's last name, so let me approve the case. Or when he came to the office, I liked his skin color. No, it's not based on these kinds of, opinions or judgments. It's based on the law. And that's what we're going to be looking at. So it's based on factual things and the law. Okay. Now, the BIA, or the Board of Immigration Appeals, they've said that discretion is a matter of administrative grace, where the applicant has the burden of showing that discretion should be exercised in his or her favor. They said it's in a case law. We won't go into what case law is. Okay, so you may qualify for a green card, but if USCIS says that your case does not deserve an approval, they can deny it using discretion. Okay, now let me come here and we're going to share my screen. We're going to go over the bear with me, bear with us. We will be answering all your questions. Okay, great. All right. Now we've spoken about discretionary analysis, the fact that they are going to review all relevant specific facts and circumstances in your individual case. That's how they determine, are there any issues that shows that you don't deserve what you are asking for. And again, an officer cannot exercise their discretion arbitrarily, inconsistently, or in reliance on biases or assumptions. We've talked about this. Now let's go on. Let's jump to immigration benefits that involve discretionary review. The first one is petition to classify an alien as a non-immigrant worker. It does not involve discretionary review. Obviously, there are some exceptions. Then number two, petition to classify an alien as a fiancé of a US citizen. That's the K1 petition. It does involve discretion. If you're coming in as a K1 fiancé, or to get you, first of all, you need to get the petition approved. It does involve discretion. And then application to extend or change non-immigrant status. It does involve discretion. So here, if, for example, you are trying to change your status from B2 to F1 as a student, it involves discretion because the officer wants to make sure that, sometimes what will happen is that some applicants, so the law says that if, for example, you're trying to change your status from B2 as a visitor, you enter the US and now you're like, okay, I want to go to school. You want to change to F. And you have to change your status before the expiration of your I-94. Okay. Once your I-94, the period of your authorized stay expires, you are not allowed to file a change of status. Obviously, there's some exceptions, but if you come in on a B2 visa, you are given an I-94. It doesn't matter, you have a 5-year visa. You cannot come and stay for 5 years. You will be given your I-94 period of authorized stay by CBP, and you have to follow it. And so you have to file the change of status before your I-94 expires. So if you're given 6 months or 4 months, if you're trying to file a change of status, it must be before. Now, in some circumstances, some people maybe they came on a B2 visa, they came to do some shopping, they were on their way to the mall, they had an accident. I've seen some of these cases, and these people were hospitalized. So instead of leaving on their 4th month, as they had planned, the doctor says that your leg has an injury and you have to undergo therapy, you have to undergo medical treatment. And so it might take an additional 5 months. You don't just stay in the hospital and forget about, your status. You have to file or apply for an extension of your status of the B2. And typically you should do it before the expiration of your I-94. But sometimes some people, maybe they were hospitalized, they were unconscious for a long time. And so we can apply for a change of status non-pro-tank. Okay. This means that even though you are applying for the change of status after the expiration of your I-94, the government should adjudicate it as though you submitted your application for change of status before your I-94 expired. That's non-pro-tank, Latin for now for then. Okay, so in those type of cases, there's discretion because the officer will look at the fact that, oh, you were hospitalized, you couldn't have followed the law to the letter, and so long as there's evidence, they can exercise discretion in your favor. Okay, so that's what we're looking at now. We're looking at the types of immigration benefits involving discretionary review. The 4th is advance permission to enter as a non-immigrant. That is, the form I-192, or you have the INA section 212D3A, a waiver to enter, advance permission. Okay, now humanitarian parole also involves discretion, the use of discretion by the officer. TPS, temporary protected status, it involves a discretionary analysis. If you submit an application for TPS, officer will determine whether you warrant a favorable exercise of discretion. Refugee status, yes, it involves discretion. The exception is where you are doing a follow to join refugee adjudications. That's the exception, but generally refugee status involves discretion. Asylum also involves the use of discretion. If you apply for asylum, they'll do a discretionary analysis to see if you warrant a grant of asylee status. And then the next one is petition to classify as an alien as a family-based immigrant. This also involves the use of if you are petitioning to classify an alien as a family-based immigrant, it does not involve the use of discretion. I-130s are non-discretionary. So long as you can prove 2 things, the case will be approved. You prove the immigration status of the petitioner, and you prove the underlying relationship between the petitioner and the beneficiary. It's approved. Obviously, there are some exceptions. As for law, there's always all these exceptions, and that's what makes it a little complex, right? Because that's some exceptions right there. I would even say, for example, Adam Walsh Act. If you're an I-130 petitioner, yes, let's say you're a U.S. citizen, you're trying to file for your spouse. And the Adam Walsh, if you have certain types of criminal convictions as the petitioner, you are not allowed to petition for your spouse or your child, even though you may be eligible. That's an example. Now, the next one is if you're petitioning to classify an alien, an immigrant, as an employment-based immigrant, there is discretion. There is discretion. That's where they look at, have you ever, worked unlawfully, or they look at so many other factors. Okay, if you're trying to get an employment-based immigrant classification, that's, let's say, the EB1, EB2, EB3, EB4, EB5, EB1A, EB1B, EB1C. These are employment-based immigrant classifications. They too involve discretion. Then petition to classify an alien as an immigrant investor, this is the EB5. It does involve the use of discretion. Adjustment of status, very famous adjustment of status. It involves the use of discretion. Adjustment of status is where you are trying to apply for a green card. You are adjusting your status. from non-immigrants to lawful permanent residents, yes, it does involve the use of discretion. But there are some examples like, the Nicaraguan adjustment, NACARA, what we call NACARA relief. That's one of the examples, the exceptions. Then an adjustment of status that's based on the Haitian Refugee Immigration Fairness Act, the HRIFA. Also, there's no discretion. And then the Liberian Refugee Immigration Fairness, LRIF law, that was for Liberians to get green cards. Also, there was no use of discretion. Okay, there's no use of discretion. That eligibility period is over. There was a timeline for that. Okay, so adjustment of status application for a green card generally involves the use of discretion largely. These are just a few exceptions that don't require the use of discretion by the officer. Then we talk about registration. If you are applying to register permanent resident status, that's also trying to apply for a green card. It is, there's no discretion over there. There's no discretion. Let's just pick some of the most important ones. Waivers of inadmissibility, like a 601 waiver, 601A waiver, and then 602, the form 602, all those types of applications, they require discretionary analysis by the USCIS officer. Then consent to reapply for admission after you've been deported. It does require discretion, okay? Because you've been deported. If you want to come back, you got to tell us why we should let you come back in. It's not just about being eligible. Well, you were deported because you probably did something wrong. Okay, so that's the reasoning of the government, not mine. You probably did something wrong. And so, well, tell us what has changed, like why we should exercise. Like if you, for example, had some type of criminal inadmissibility, how have you rehabilitated? Have you reformed? Have you become a better member in society? Tell us about that before we can approve your waiver. It's not just about having the qualifying, qualifying relative and showing extreme hardship, but there's also the discretionary analysis. Then there's employment authorization, another famous one. Work, green cards. Work permits. Authorization to work. If you want to work in the US, you need a work permit. It does involve the use of discretion. Generally, it has some exceptions. Then removal of conditions on permanent residence. No use of discretion. No use of discretion. If you qualify, you qualify. However, there's an exception here. Removal of conditions, there's no discretion. Okay, the joint removal of conditions has no discretion. But if you are filing a family-based conditional permanent resident application and you are requesting that the government waives the joint petition requirement, then you need to show that you warrant a favorable discretion. So if you are doing the application as a waiver request based on the end of your marriage, based on battery, you've been abused, based on extreme cruelty, extreme hardship, it is a discretionary decision. So when it comes to removal of conditions, the joint petitions, no discretion, you're eligible, you're good to go. If you're filing the removal of conditions based on the waiver, there is a discretionary analysis performed by the officer who's going to review your case. Then naturalization, another famous one, almighty citizenship for foreign-born nationals. There is no discretion. If you are eligible for naturalization, you are eligible for naturalization. You either qualify or you don't. Then application for certificate of citizenship. This is for people who, let's say, they acquired US citizenship automatically by birth, or maybe they were derivatives, and then they got citizenship by derivation, by acquisition, and they are looking for the certificate of citizenship. There's no discretion. You are a citizen or you are not. Okay. Now let's go to Let me see here. Eligibility threshold. Okay, let me go to let's go to green cards. Let's talk more about this. What I was reviewing was chapter 8 of the USCIS Policy Manual. We're going to go to chapter 10. Chapter 8 talks about general discretionary analysis, but chapter 10 specifically talks about discretionary analysis as it relates to green card applicants. Okay, as it relates to green card applicants. So let's focus today on green card applicants, because there's just so much under discretion. We won't have time, and I want to be able to take all your questions. So start dropping your questions. Once I'm done, we'll take questions and see how best we can assist everybody as much as possible. All right. So when you talk about your green card, when you're applying for a green card, you absolutely, adjustment of status, you have to show you warrant a favorable discretion. We talked about some of the exceptions. Don't worry about that. Many people don't, qualify to apply for the green cards under those exceptions. So the majority of the people need to show that they deserve their green card, and which is why sometimes it's good to use a lawyer, because people say, oh, why should I use a lawyer? Well, I can fill out forms and send it by myself. Well, why should you buy fried rice? You can probably cook rice by yourself, but once you cook it, it might not taste as great and as spicy and as delicious as the chef who's making fried rice, making 500 bowls of fried rice every day and has perfected the art. And so you get to save yourself some sweat, you get to save yourself stress. It's just ready and you eat and enjoy. Of course, US immigration has higher stakes, and so it's not fried rice. There are more important things, right? Because it affects your future in the United States and generations after you. Being able to live well in the United States will not only affect you, it will affect everybody in your life, in your bloodline. Okay, so you have the power to make things better or worse for your generation. So it's important that you use an attorney, because we're able to advocate for you where we have to show that you warrant a favorable exercise of discretion. We're able to highlight these things in your favor. Now, standard of proof is different from burden of proof. Standard of proof is the persuasiveness of your evidence. What's the quality of the evidence you have? Burden of proof can either be on you, the benefit requester, depending on the type of application you're applying for, or it can be on the government. Okay, so usually if you are applying for a US immigration benefit, the burden is on you. You are the one that wants the green card. You got to prove to the government, the US government, why they should give you a green card. The burden is on you. Take criminal prosecution. The burden is on the government to show that Mr. X committed murder, not on the person that you've accused. They don't have to come to court and start disproving. The burden is on the government. Then once the burden, the government who has alleged has proven their case, then the defense will also come in why Mr. X didn't kill this person. But burden is first on the government, then it shifts to the accused. When it comes to immigration, in this case, adjustment of status, for example, if you're in immigration court, the burdens can sometimes change. The standard of proof can also sometimes change, right? But here we're looking at affirmative immigration applications. You are the one that wants a green card. Well, tell the US government why they should give you a green card. You're not able to make your case stamped denied. Okay, so the advocacy is good for you because we're able to highlight these things to the government. All right, so let's go on to, I think we already discussed, okay, now let's come here. Let's look at, okay, let's go back again. NACARA, the non-discretionary adjustment of status provisions, the NACARA, refugee adjustment, Haitian Refugee Immigration Fairness, HRIFA, no discretion. When it comes to application for green cards, these use discretion. Number one, family-based, we talked about employment-based. The diversity visa adjustment also absolutely uses discretion. Then special immigrant-based adjustments, EB4, trafficking victim-based adjustment. If you're a victim of T visa, for example, T visa green card case, discretionary is used. Crime victim-based adjustment under the U visa, discretion is used. Asylee adjustment, you're an asylee trying to apply for a green card, discretion is used. Cuban adjustment, discretion is used. This one, Luxembourg parolees, discretion is used. Diplomats or high-ranking officials under Section 13. If you are applying for a green card as a diplomat under Section 13 of the Immigration and Nationality Act, discretion is used. Guys, if you can hear me and see me, please drop USA, keep dropping, keep dropping. Let me make sure I'm not talking to myself and you guys can hear me and see me really good as I continue. Please drop USA if you're here with me and can understand what's happening. Okay, drop emoji, type in USA. Let's see here. Okay, now guys, let's go to what are they looking at? What is immigration looking at to determine should they give you the green card or should they not give you the green card? Number one, they would look at eligibility requirements. That is fundamental. Okay, that is fundamental. They're going to look at your eligibility. There's something I'm looking for here. Hold on. Oh no, not this here. Okay. Yeah. Okay. I'm going to tell you something really important first before we start looking at the factors. Looks like I don't have it on this screen. So let me pull it up from here. I just have multiple. Okay, great. I think it's right here. Okay. It's right here at the bottom of the screen. So an officer must first determine that you meet the statutory and regulatory eligibility requirements. So let's take a look at an adjustment of status under Section INA 245A. That's where green card applications, they look at whether you're eligible or not. First of all, the officer must determine if you are barred or you cannot apply for something called an adjustment of status. Number two, you should be eligible to receive an immigrant visa. Number three, you are admissible to the United States, meaning you are not inadmissible. You don't have any criminal issue, health issue that makes you inadmissible. In the past, if you had HIV/AIDS, you were inadmissible. I believe they took it away in 2002. Now, people with HIV/AIDS they're admissible, they can be granted green cards, but in the past, you were inadmissible. If you're inadmissible based on health grounds, it means you cannot get a green card until, something is done about that. And then, so you should be admissible. You shouldn't have committed fraud. You shouldn't have any criminal inadmissibility, health inadmissibility, public charge inadmissibility. There are different grounds of inadmissibility. And there should be a visa available for your case. For immediate relatives, no visa. They don't have to wait in line for a visa to become available. There's always visas. For preference immigrant, employment-based, diversity visa, they have to wait for a visa to become available for their case. All the other cases, apart from immediate relative, don't have to wait. Okay. Now, once you meet all these eligibility requirements, then they'll determine whether your case should be approved as a matter of discretion. Here are the things they are looking out for. Number one, eligibility requirements. That's a fundamental analysis that they make. The first thing is, are you eligible? You should meet all requirements. If you don't meet all requirements, then they will not even move on to discretionary analysis. If you met all requirements, then you should be good to go. Okay. Now, not meeting an eligibility requirement. For example, the law requires that if you're coming into the US to apply for an adjustment of status, you should have been inspected and admitted or inspected and paroled. There are some exceptions as always. For example, VAWA. If you came in through the border, you jammed the California wall or whatever, you can still stay in the United States and get a green card. Okay, generally, however, if you did not come in with permission from the US government, they are not going to give you a green card in the US. They'll tell you, go back to your country, go file a 601A waiver. Well, you file the 601A waiver, unlawful presence. If it's approved, you go back to your country and you get the immigrant visa to come back in. They want to disincentivize people from just coming in without permission. They don't want to encourage people like, oh, okay, if you even came in without permission, then you could still get a green card anyway. Then people say, oh, then that's good. Then I'm not going to come in with a visa or with a parole. I'll just come in. So if you, for example, you came in unlawfully and you apply for an adjustment of status, you are married to a US citizen, you're like, oh, I want to get a green card. You don't meet the eligibility requirement, so they will not even bother considering discretion, because the fundamental thing you haven't even met. And not meeting eligibility requirement is considered in any case as part of the discretionary analysis. So why should you even warrant a favorable exercise of discretion? Before we continue, let me tell you guys that, you know, there have been a lot of issues even with these policy updates, because this was updated in 2020. Before 2020, it was less strict, but President Trump, when he came into power, this became the really heightened the discretionary analysis. And there were a lot of complaints that it was unlawful because there was the government was trying to heighten the burden on non-citizens, because the burden is by preponderance of the evidence, standard of proof, preponderance of the evidence. But they were like, no, this discretionary analysis is too complex. Look at all these things that a person must prove just to show that he warrants a favorable exercise of discretion. Is that not substituting clear and convincing standard for preponderance of the evidence standard? Clear and convincing standard is like here, preponderance of the evidence standard is here. You need preponderance of the evidence to get your green card case approved if you're filing through USCIS generally. Clear and convincing is a higher standard. And so they're like, all these things these people have to prove. It's like it's rising to a level of clear and convincing evidence. That's not what the law says. You know, so there are arguments about that. But we're not focusing on those things now. I'm focusing on what is the government going to review to approve or to deny your case, which is what you want to be concerned with at this time. The government is going to look at your family and community ties. What are your family ties to the United States? Closeness of underlying relationships. Do you have 5 aunties, 20 children, 50 cousins, uncles, you know, close families? Your husband, your wife, your in-laws, you are a lot. That's helpful for you. It's a positive factor. If you are, I come alone, I walk alone, it's a negative factor. It's right there. Absence of close family, absence of community, absence of residence ties. Those are negative factors for your green card case. Okay. Now, another thing I'll tell you is that if you are generally eligible, then and you don't have much, any negative offsetting factors, then the discretionary analysis is not very complex or bad. You can be just alone. You have a spouse, she's married to you. You can get a green card easily. The problem with the discretionary analysis is when you have a lot of negative factors and you are looking for positive factors to offset those negative factors, right? Like you've gone to commit, you have some criminal record, and now they have to now look for positive factors to offset that. That's when they'll start looking. Do you have family members? If we don't give you a green card, what's going to happen? But generally, not having a close family member should not affect your green card case. Okay, I hope this is clear. But they're looking at, do you have community? Are you close with people in the community, your church, your neighborhood, right? Then they're looking at hardship to the applicant or your close relatives if your adjustment of status case or green card case is denied. Length of lawful residence in the United States, status you've held, and your conduct or your behavior during that residence. So you've lived in the US, and to be honest, they don't only look at lawful residence. If you've lived in the US for 20 years and your behavior during those 20 years were very bad, You go around slapping your neighbors, you are cursing, you are always being arrested for disorderly conduct, you're fighting with people on the streets, in stores, resisting the police arrest, just causing mayhem, that is a negative factor. But if your conduct has been wonderful, amazing, supportive, you volunteer, you are just wonderful, that is a positive factor. So your conduct during your residence in the United States, then, the status you've held, especially if and they also look at, have you been here in the US since you were young, since you were 2 years old, 3 years old? They understand that, when that happens, it means that even in the country that you are really from, if you are deported to that country, you don't have anybody to go to. You've grown up, you came at 2 years old, and now you are 25. They'll consider that you've lived your whole life pretty much here. So that is a positive factor if you've lived here for a very long time. Then immigration status and history, they're looking at your compliance with immigration laws. Have you violated immigration laws? Have you overstayed? Have you worked without authorization? And now this is what the government is doing now. They are using discretion a lot more. They're looking at things like overstay, unauthorized employment, to deny people even though they may be eligible for their immigration benefits. And so you need to be able to balance the equities very well to make sure that you submit evidence showing that you warrant a favorable discretion and that your positives outweigh or offset your negatives. Okay. You have countervailing positive factors that will merit a favorable discretion. Okay, so approved humanitarian-based immigration. I won't go into all this. It looks like it's a lot. You guys can see if you have an unexecuted order of deportation, you were ordered deported 10 years ago, you are still here, is a negative factor. If you have previous instances of fraud, false testimony in dealing with USCIS or any government agency, is a negative factor. Business employment skills. Okay, so if you own property in the US, it's a positive factor. You own investments in the US, wonderful. They love it because you are bringing them money, so they want that positive factor. Which country doesn't want that? You have business ties in the US, wonderful factor. History of unemployment, underemployment, you're always taking, benefits, unemployment benefits, all these other things. It's a negative factor because it shows that you are somebody that is a drain on the society. Nobody wants a leech in their lives, right? The US government is no different. They also want people who bring money. So if you have you're applying for a green card and you have a sugar, let's say maybe a sugar factory or a drink factory, and you're raking in or you're bringing in $100 million a year, you've employed 70 people in your community, you are paying taxes. It's such a positive factor. They love it. Okay, so they're looking at your employment history. Can you keep a job? Employment type. Not that you are working in prostitution. They don't like that. They want you to be working in good stuff, like, you're helping vulnerable, you're a teacher, you're helping special needs, you're in the medical field, you're doing pro bono with law, helping, you're working with Walmart. These are good jobs. Okay, so they'll look at your employment type. They'll look at the length and the stability of your employment is a positive factor. If you have unauthorized employment, I've mentioned negative factor. If your employment is from illegal activity, prostitution, it's right there, gambling, alien smuggling, they don't like that. Drug sales, negative factor. If you have education or specialized skills, guys, imagine if you were the only one in the US who could conduct a certain type of surgery, maybe some eye surgery, and the whole United States, you are the only one that can do this type of surgery. Oh my goodness, that's a positive factor. How would they even deny you a green card? They need you more than you need them, right? So think about it that way. If you have some specialized skill or some skill that is sought after, they'll be quick to give you a green card. It's a positive factor. You have training that you've obtained from an educational institution in the US that's relevant to your current or prospective employment, and your earning potential in the US is great, they love that because you're going to make money and you will pay taxes. Okay, positive factor. Then they are looking at your community standing and your moral character. You have respect for the laws in the United States, good moral character, even abroad. You haven't killed 10 people in the past or even one person in the past. You are not beating your wife. You are not, you are just somebody with good moral character. You are paying your taxes. There's a lack of criminal record. Evidence of good standing in your community. You are doing everything as you should do. Honorable service in the U.S. Armed Forces. You've served the country. Positive factor. You compliance with tax laws. You are paying taxes to the IRS. Positive factor. And now these same people are going to use IRS data to find people and try to deport them. But well, we've always known that compliance with tax laws is always a positive factor until recently. And so that's that struggle or that conflict there. Current or past cooperation with law enforcement authorities, positive factor. You've demonstrated, so meaning you've worked with the police. When the police needs information, you are first to raise your hand because you saw it and you're so helpful. You cooperate with them, you help them. The police is your friend, all of that. And they can attest that, oh, this man is really good. Demonstration of reformed or rehabilitated criminal conduct, positive factor. You were arrested 15 years ago. You were doing a lot of drugs. You've cleaned up. Now, guess what? You're a police officer. Or even you're a teacher in kindergarten. You now have a wife. You have 3 young kids. Every Sunday you're going to church. You kept your job for 4 years. The last 4 years, clean, squeaky clean, criminal record. Like nothing happening. You are doing so amazing. That is a clear demonstration of reformed or rehabilitated criminal conduct. And despite your past, we can make a case and show that, look, this was the past. This man is a new man. Look at him. He's living life. His adulting is truly adulting. Look, he's doing great. Family man. He's at the water park with his kids. He's carrying his kids on his back. He's celebrating birthdays. We have pictures to show. It's a good positive factor. Okay, negative factor we've talked about. There's lack of reformation or character or rehabilitation. The same behavior. You were slapping people 10 years ago. You are still slapping people. You haven't changed, and people have filed cases against you. Is a negative factor. You failed to meet your tax obligations. You've been working. You've never paid your taxes. They're like, this guy is not. We don't want this type of person here. Is a negative factor. And this other very, very, very popular one, failure to pay your child support. Highly negative factor. You have young children, and the mother of the children has to always go to court to try to enforce, you have to, you're supposed to pay maybe $1,000 for the 3 minor children every month. You don't pay it. This is not a positive factor. It can be used against you. Okay, we're almost at the end. We're going to, and then, community service beyond any that has been imposed by the court. So let's say 10 years ago, you were caught selling drugs and you were given community service that, every month, maybe you have to come and do this, serve here or do this. After you've done that, you've served that sentence imposed by the court, that community service imposed by the court, you are now like, you know what, the court said every month, maybe I should go and clean up something. But I think I enjoy it. I enjoy working in this school or in this public institution. I enjoy cleaning the place up. And so I'm going to go beyond what the court has imposed. That's wonderful. That's a positive factor. Positive factor for your case. If you fail to comply with applicable civil court orders that do something, you will fail to do it. Disobey it is not a positive factor. And then where there's an absence of, so positive factor is the absence of significant undesirable, or there's an absence of negative factors and other indicators of good moral character in the United States and abroad. if you have any other factors that reflect your character as bad or undesirable as an LPR, lawful permanent resident, then that is a problem. Okay. We couldn't get into the calculations for how they do this discretionary analysis. It's also it's another it's another discussion. That will take time. So maybe we should answer some questions now. I see some questions here. We're going to answer them. Let me see. I'm going to pull this up very quickly. Right here, we discussed this employment base. Yes. So Kweku Owusu says, does discretionary actions apply to EB3 scaled base categories, both I-140 and I-485 and EB2 after I-140? Okay. So EB3 scaled base category, employment base 3 under the scaled category, it does use the discretionary analysis right here. If you can see on the screen, that is petition to classify an alien as an employment-based immigrant. It includes EB3. This is, I believe, the chapter 8 of the USCIS Policy Manual. So they use that to determine whether you should be granted the EB3. Then the 485, which is the adjustment of status, it uses discretion as well. There's a discretionary analysis. When it comes to EB2, EB2 is the same as the I-140. It's the I-140 you use to apply for the EB2. EB2 is, the category is EB2, but the form is I-140. That also you need, the officer is going to look at discretion. They're going to do a discretionary analysis to determine, okay? All right, let's see if we have another question here. Thank you for joining, Prince. I hope I haven't, okay, great. All right, guys, if you can see me, hear me good, please drop the flag and then we can take your questions soon. Charlie Zoo says, I have a question. I was not prosecuted for fare evasion on the subway, but was only fined. In this case, do I need to inform when filling out the form 485? Please, this one, let's see what happened, and then we can determine, what advice to give you, okay? So that we don't give you something that will not help you, okay? So please contact us and let's see how we can help you with that. Generally, for 485, you're just required to, the questions are, have you ever been arrested? Have you been convicted of a crime? So it depends on what happened, and we can take a look at that and determine what you should do. Okay, Prince Fiazibe says you need an expert in some of these things, and that's where AK Boku Law comes in. Thank you very much. Apia Gilbert says, I'm looking to getting an F2 for my wife to join me in the US. Is that possible, specifically at this time when F1 interviews are on hold? Yeah, there's, a lot of the media outlets said that there was a cable released by the Department of State that said, student visas, they shouldn't schedule any more student visas, but we still haven't seen the original cable released by the Department of State. But it looks like, these are reputable media outlets that are saying this. So we don't know what's happening with that. It just says that their F1 student visas are on hold because they want to do more vetting. It's not clear whether F2s, dependents of the F1, spouse and minor children of a student, it's not clear whether that's on hold too, but likely because they are connected to the F1s. But we'll see within the next coming days. Maybe we'll get more information to determine that. Okay. All right, guys, drop your US flag if you're enjoying the session. Let me see if I can get some questions on Instagram. AZM Auto says, what is the most important thing I need to know as someone who's preparing for I-130 interview? Is it just the I-130 interview you're preparing for, or you're also going to prepare for the green card interview? Well, I-130, I already said it when we're discussing this, this discretion. I-130, there's no discretionary analysis. There's never been discretionary analysis generally. There are some exceptions there, but I-130 interview, they're looking at two things, as I mentioned, the immigration status of the petitioner and the claim relationship between the petitioner and the beneficiary. So I-130s are filed by green card holders and US citizens. So they need to show to immigration that they are US citizen, and number two, they need to show to immigration that the person they're applying for is their wife, child, fiance, sibling, parent. If you're a green card holder, you show you're a green card holder, and number two, you show that the person you're applying for is your spouse or your unmarried child, either under 21 or above 21. So they're looking at the bona fides of the relationship underlying if it's a marriage, the marriage, if it's a parent-child relationship, what are the bona fides? Did you just create a birth certificate in 2022 to say that this person is your child when they're not? They're looking at bona fides of the relationship, usually the bona fides of the relationship. The 485 or the adjustment interview goes into admissibility, eligibility, and discretion. But the I-130, there's no discretionary analysis, okay? All right, let's see if we have somebody here. Instagram, I am Deshaun. He says, any advice on staying in the US for 90 days on visit and wanting to apply for a student visa? So if you came into the US on a visit and you trying to change your status to a student visa, generally not recommended, because immigration doesn't really like that unless you can show that you came in and then the students thing happened, right? If you came in with a B2 visa and before you came in, you already had this, the school admission, that can work against you. It's not impossible because even at our law firm, we've done a lot of change of statuses for people from B2 to F, but we review the circumstances of their case and then give them proper advice. But it's possible. It depends on the type of visa you come in with, and then we can determine if it's doable or not, okay? And your timing, when did you get school admission? Did you come in before you applied for the school and got the admission? If you knew you wanted to come to school in the US, why didn't you apply for an F visa in your country? Were you trying to evade something? So they look at all these things. Let's see if we have some questions on TikTok as well. Queen Erica, she says, what could you do if you overstay? There's a lot of things you could do. Well, quite a number, not a lot. I shouldn't say a lot because they're quite limited, but yeah, absolutely. You can call us and then we can discuss that, what should you do if you overstay? If you overstay, generally, there's just very limited ways you can regularize your status. It's either through family-based immediate relative category or through the humanitarian basis, like S visa, T visa, U visa, asylum, VAWA, immediate relative, like your spouse of a US citizen, or you have an adult child who's a US citizen above 21, who can file for you, then your overstay will generally be forgiven, but yeah, so certainly call us and let's see how we can help you. Also, Asante Kwesi says, how do you know if your visa is revoked or otherwise? What type of visa is this? Practically speaking, for B2 visa holders, if your visa is revoked, normally they'll tell you bring your passport back to the embassy. Then you go and then they'll tell you your visa is revoked and they'll cancel it. Or sometimes they'll email you that your visa is revoked. If you're in the United States, your visa is revoked, Department of State will email you. Let's say if you're on an F visa. We've seen that very often these days. They'll email you that your visa has been revoked. They've learned some derogatory information. So, okay. If Kwanaki says, if I get a ticket for distracted driving and I'm to pay a fine, does it affect anything? It depends. I can't tell, which state you're in, what the citation was, how much the money was, what your current status is, what you're trying to apply for. All those things will factor into my response to you. All right, guys, thank you so much as always for joining. I really appreciate it. If you've enjoyed this session, please give us a thumbs up, type in USA, follow this page, AK Poku Law, share our page across social media. Obviously, if you see our posts, just don't pass by. It doesn't cost $1 to like our posts, just like, comment, and you'll encourage us to do more. We appreciate your presence here, and hopefully I'll see you guys next week. Okay, so take care, have a great weekend. Bye. Thanks for joining.